Here. Okay, welcome everyone. Glad you all could make it to a special briefing for, especially for state legislators, but also with their activists about what's often called the Article 5 Constitutional Convention, sometimes called a Convention of States or Amendments Convention. My name is Eldon Stahl, and I have a special guest this evening. His name is Robert Brown, and Robert is fairly well known across the country. Talking about the Constitution. He's been a regional field director with the John Birch Society, as well as a coordinator, and also probably best well known for his 6-part lecture series called The Constitution is the Solution. And probably, I don't know, what would you say, Robert? Thousands? I don't know, tens of thousands? Who knows how many have seen it, right?
It's probably in the tens of thousands at this point.
Tens of thousands.
I know that many thousands of the sets have been sold and have been used and shown to quite a few groups throughout the country on a regular basis. So it's not totally trackable, which might be a good thing.
Yeah.
but yes.
It's really kind of a neat thing to think that all these people might have seen it. I've certainly enjoyed seeing it a number of times and shared it with others in different groups. So
it's been fun as I travel the country. I often run into people that have seen the video series and share with me how much that has helped them understand our founding documents. That's always gratifying. Anyway.
Yeah, definitely. It's certainly recommend it to anybody that has not seen it. You can order it on a disc or YouTube or look on it for free online and all of that nowadays. So it's really neat.
Yeah, on YouTube, The Constitution is the Solution. You can pull up a bunch of different videos under that title, but there is at least one place where there's 6 lectures all in one playlist. So you can get the whole package that way.
Yeah, that's really a handy thing, isn't it? So, okay. They had somebody else to admit, but I guess not. All right. So Robert, I guess the title of this presentation is an Article 5 Convention, What Are They Not Telling You? Is that right?
Did I get that right? That's correct.
Okay. So I assume by that title that you're saying that, there's some things that they, whoever they is, right, are maybe not telling us, and maybe there's something that would be useful to know for those concerned about or considering an Article 5 Constitutional Convention or whatever you want to call it. Is there maybe other things that aren't being told that might be of material facts, as they call them in the courts?
Yes, absolutely. Probably one of the biggest problems I have in talking about this topic is that there are so many. We really could go till midnight tonight going through all the different things of very solidly documented evidence that is contrary to what our state legislators are being told when they're being presented this, hey, you need to sign on to this application for an Article 5 convention. It's so much so that a few years ago in Nevada, for example, they had applied for the convention, and upon seeing more information, as more information came in, they passed a resolution in their legislative assembly, their house, declaring they had been induced by fraud, was their wording, a little bit bold there. They'd been induced by fraud to apply for a convention because they had not been given the whole story, is kind of their position. A few years later, it eventually got to the point where the entire House and Senate took up the rescind movement, or the rescinding effort, and unanimously in both houses rescinded their application for a convention. It's one of those things where when enough information is given on both sides, I feel like we always win, because honest men and women, equally informed, rarely disagree. And so that's my intention here, is just to help people have more information that isn't normally shared with our state legislators on this topic.
Okay, so what would you say maybe is some top ticket items, things that are
pick a few of the big ones.
Well, no, yeah, pick a few of the big ones that maybe if you're a state legislator and you're considering this, what are some of the common claims made, and they maybe we should know a little more about that, or what would you say?
I would say in visiting with other state legislators around the country, I've heard probably what they feel are some of the most compelling arguments, and those are where I'd like to start. That the most compelling arguments in favor, the ones that make us feel like maybe this is a good idea. And I'll list those as probably the top two. Number one, this is a process that's totally controlled by the states. And number two, there is no other option.
Now,
and we'll go into each of those a little in depth. Go ahead.
I should have probably given you the opportunity for those that are maybe watching this on a recording that are not familiar. Just tell us, what is an Article 5 convention? Just lay the groundwork there.
So, in a nutshell, in the Constitution, the way to make changes to the Constitution is outlined in Article 5. And in there, it defines two different ways we can make amendments to the Constitution. The first way, Congress proposes the amendments, they pass it through the House and Senate, each with a 2/3 or more majority vote. Then it goes out to the states, and the states have the opportunity to ratify those changes, requires 3/4 of the states to do that. And Congress can choose whether that's done through the state legislatures or through special ratifying conventions. Every amendment that we've ever made to the Constitution, including the Bill of Rights, followed that process. All of them but one were then ratified through state legislatures. Only one, the 21st Amendment, repealing prohibition, followed the second ratification route where they bypassed state legislatures and had it ratified instead by special committees called in each state, ratification conventions. And so that's the process we've always used. But there is another one in there, never used before, which is partially why it raises so many questions. When 2/3 of the state legislatures apply to Congress for a convention, then Congress has the role of calling a convention for proposing amendments to the Constitution, and then the same ratification options apply, that it can go out to the states for ratification either through the state legislatures or through special conventions held in each state, bypassing state legislatures, with, again, 3/4 majority vote, 3/4 of the states ratifying. And so that is the Article 5 convention process, never been used before. And a number of groups today on both sides of the aisle, liberal groups and some conservative groups, both pushing this for various agendas. Liberals have some of their ideas, such as we want to have campaign finance reform. We want to get rid of the Electoral College, things like that. On the conservative side, we see things like we need a balanced budget amendment. We need term limits. We need to rein in the federal government in various ways. And so there are a lot of different reasons for which they're pushing for an Article 5 convention, is probably the most appropriate title, often called Convention of States or Constitutional Convention. But so that's the background of what this is about. And then where we get into the real details is who controls it, how is it controlled, how does this process actually work, what kind of power does the convention actually have based on historical precedent, and so on. And that's where the real details come into it.
Okay, so I guess basically it's a way of changing the Constitution that we haven't used before. Mm-hmm. So what could be maybe a concern there?
Yeah.
Or maybe we should start as originally we said. Okay, what are some things that maybe some people have made claims, and maybe we should know a little more about it, or what? I keep hearing people say, well, each state would get one vote. That's a common thing. But just as an example, maybe you want to touch on those.
Sure, certainly. And really the concerns come into when you make a change to the Constitution, it's essentially like etching in stone some legislation that is almost, not quite, but almost impossible to change thereafter. We've only ever once changed an amendment when we had prohibition through the 18th Amendment, repealed through the 21st. Only time that's ever happened. And it's very difficult. You make a mistake in amending, you're pretty well likely going to be stuck with it. So there's definitely some concerns there.
Is there an instance that you would say would be appropriate to change the Constitution?
That's a great question. And actually the founders touched on that topic repeatedly. They talked about using Article 5 in either mode, whether it's through Congress or through the convention mode. Every time they talk about that, if they give any context for when it should be done, it's always in addressing errors or flaws that are found in the Constitution. And in fact, Madison does take up in one of the Federalist Papers, Federalist 49, the question, should this also be used for reining in those who breach the Constitution, correcting breaches to the Constitution, those who violate the Constitution? And he spends all of Federalist 49 explaining why that would be a bad idea. That if the federal government's blatantly ignoring the Constitution, here's why it's not the proper tool for that. And he then ties it back into Federalist 48. Federalist 48 just simply talks about, in modern wording, rules on paper can't enforce themselves. He refers to them as parchment barriers. And so if the parchment barriers have not proven to withstand tyranny stepping beyond their bounds, it's absurd to think writing some more parchment barriers is going to fix that problem. And so Federalist 48 and 49 is saying, here's not what to use it for. Federalist 43, Federalist 85, and several other writings of the founders go into the idea of using the Article 5 Convention for correcting errors in the Constitution. And on that note, balanced budget amendments, one of the topics I've mentioned. Sometimes people will say things like, well, isn't the fact that there's no balanced budget requirement in the Constitution, isn't that a flaw in the Constitution? To those who understand what the constitutional limits on spending are, then no, it's not. If the constitutional limits on spending were actually observed today, the federal budget would be trimmed by at least 80%. We'd be down to 20% or less of its current size. We'd have somewhere in the range of a $2 trillion annual surplus. Under those circumstances, do you need a balanced budget requirement? No, not at all. We would be so far below just merely balancing the budget, we'd have a massive surplus. The constitutional way of addressing spending is so much superior to any balanced budget amendment proposal I've seen. And they always run the risk of being too stringent or too loose. If they're too stringent, for example, you cannot in any circumstances ever spend more than you take in. Then we go to war and we end up spending more on the war than we take in. We have to surrender because we can't spend more than we than we take in. Yeah, we'll be a conquered nation, but at least we went down with the balanced budget. You know, that's absurd. But that's one example. If we have the balanced budget requirement too stringent. On the other end of the spectrum, the one that's out there being pushed right now, that's been pushed for the last 30 years, literally says we want a balanced budget amendment that would require Congress to balance the budget in the absence of a national emergency. Which, when was the last time we didn't have a national emergency? Do you know?
A long time ago.
Yeah, it was 1979. That was the last time, even for 1 minute, we didn't have a national emergency declaration on the books in effect at the time. So, of course, that is so wide open, they'd never have to balance the budget. So that's just one example of, is that really a flaw in the Constitution? Not at all. Because I've so deeply studied the Constitution for so many years, I concluded that if we just obeyed it, it would solve the vast majority of the problems our nation's facing today. That'd be a great place to start. And if once we're doing that, if we still find there's some problems, okay, we could look at if it needs some tweaks. Why don't we try living by it first?
Well, anyway, a lot of people saying, you know, we should change the Constitution, do this convention for kind of reining in an out of control federal government, that type of thing is
right.
So you're saying, I guess, that that's not the approach that the founders would recommend, at least using an amendment to do that. Not very effective or not.
Absolutely. For those who want to study into this deeper, I'm not going to go very deep into this today, just for interest of time as much as keeping people's attention. I don't want to make people get too bored with what we're talking about, but I do want to give a short list found of various Federalist papers in which Madison and Hamilton talk about what to do when the federal government doesn't follow their rules. Federalist 16 and 26, Alexander Hamilton talks a lot about power the states have to push back. And in Federalist 33, he goes into how to draw the line, where to decide when the states need to stand up and push back against federal tyranny, when they do not, and so on. He really defines the meaning of the supremacy clause in Federalist 33. Then we get into Federalist 44. James Madison talks about why our state level officials have an oath of office to the federal Constitution. And he says it's their duty to, quote, of giving effect to the Constitution. And Federalist 46 is my favorite, though, because in that one, Madison goes through powers that the states have to push back against federal tyranny and powers that the people have to push back against federal tyranny. And throughout all of that, guess what they never mention? Article 5 Convention. Yeah. It's a very common topic addressed in the Federalist Papers over and over again. What do you do when the federal government oversteps their bounds? That was one of the biggest concerns the states had. Every time they answer that question, they never brought up the Article 5 Convention. They only bring it up when they're saying that's not what you're supposed to do when this happens in Federalist 48 and 49. So just to follow their advice here alone is a pretty compelling argument. But in addition to that, there are things like, well, for example, when the Constitution was written, there was no Bill of Rights, and that was a big concern for a number of the states. We really need a Bill of Rights, and initially Madison was not on board with that. He felt like we've outlined what powers they have. There's no need to tell them you can't do something when we never gave them the power to do it in the first place, and so on. He eventually was won over to maybe it would be good to get all the states together by having a Bill of Rights. I think that'll help create more unity in the nation. But during this time of pushing for these amendments for the Bill of Rights, in particular, the state of New York and several others began talking about, well, in this new Constitution, we have this amendment process by Article 5 Convention. Let's propose the Bill of Rights through the Article 5 Convention. And Madison wrote on a number of occasions to various people saying, this is a dangerous idea. One was November 2nd, 1788. He wrote to a gentleman by the name of George Turberville. And there he says, having witnessed the difficulties and dangers of the first convention, I would tremble at the result of a second convention meeting in the present temper of America. And 2 months later, in January of 1789, he wrote to a gentleman, George Eve, almost exactly the same thing, but went further and referred to the present ferment of parties was his concern. And in that letter, he says that it's a safer mode to propose amendments through Congress than it would be through the convention. So Madison pushed back significantly on this movement for, let's have a Bill of Rights done through an Article 5 convention. Just a little bit of history there, I think it's important. I do want to get to my main 2 points, though, that I think are the main compelling arguments. The number one, states control the process. Number two, what else are you going to do? And I think I've kind of touched a little bit on that second one already with like the list I gave, Federal 16, 26, 33, 44, 46, and really tie in 48 and 49 of what not to do. The states have the power already. I often refer to this as kind of like the Dorothy Gale effect. The end of The Wizard of Oz, she discovers that number one, what she thought was the solution, the wizard, was a fraud. And number two, she had the power all along. She had the ruby slippers. And really the ruby slippers is that the states already have the power to push back if they have the political will to do so. And so that's really a topic I'd love to go into more in depth in its own discussion, rather than just taking up all of our time on that. But the fact that the founders did outline in great detail powers of the states to stand up and enforce the Constitution is really what refutes that second one. We don't have any other options than an Article 5 convention. No, well, actually, no, we do. We really do. And this year, I've seen a number of states bringing forth legislation of that nature. One that I've seen in 3 or 4 states this year already establishes a state legislative committee whose job it is to review federal law and assess whether or not it has any constitutional authority, and then give their advice to the state government based upon that. This federal law has no constitutional authority, and therefore we don't feel you have any obligation to help implement it, would be an example of how that would be used. Several states have already been introducing that one for the last few years. I've seen quite a few more step up this year on that one alone. So on that second point, there are other options, and I'd say much better options. And one more thing on that. If we feel like there's any urgency of time, we don't have a lot of time to turn things around. Comparing those two, this idea of states standing up and enforcing the Constitution can be done right now. We don't have to wait. It can be, as soon as the states feel like they want to do it, they can begin implementing it immediately. On the other hand, something like this Article 5 convention, let's take the Convention of States organization as the example. They've been around for 6 or 7 years. They're somewhere around 14 or 15 states. it requires 2/3 of the states, 34, to get to the point where the convention is actually called. So by their present numbers, they're less than halfway there after about 7 years. It's going to easily take at least 10 more years if they don't lose momentum, but they have. They've lost a lot of momentum. But even so, just benefit of the doubt, let's say 10 years out, they finally get to 34 states, and then Congress gets around to maybe the next year after that, actually calling the convention convenes, maybe takes another year for the convention to actually happen and conclude their effects. You're looking like a dozen years or so out at that point. But before that happens, many of the leaders, including leaders of convention of states, have admitted there will be legal battles all along the way that will delay this. However many number of years it'll be tied up in court before people finally decide, and we have the courts tell us who really sets the rules for this convention and what historical precedent actually applies and so on. Legal battles all along the way. Then there's the convention has their new amendments they come up with. They still have to be ratified. How long does it take on average for an amendment to be ratified? You look through history, it's anywhere from a handful of years to the longest one, the 27th Amendment, took 200 years to be ratified. And so, roughly. And so it could be anywhere number of years further. Very conservative estimate, I'd say, you're looking at about minimum of 2 decades before you see any results being implemented from the Article 5 convention. If you feel like we have 20 years or more to wait for the results of a convention, that's really what you're looking at realistically. And I would say with one exception. If the convention comes up with things that are damaging to liberty, then at that point, I feel like the deep state would push it through at record-breaking speed. But other than that, as a classic example, look at Brexit, where the United Kingdom voted to leave the European Union years ago. What is it now? 6 years ago, 5 years ago, something like that. And they're just dragging their feet, ever implementing this good measure of independence. The same kind of thing you're going to see with the implementation of any true freedom restoring type of amendments, if we even could get those. And so 2 decades minimum would be the best estimate I could give on that, and anywhere above that. Other amendment proposals that are out there, like the balanced budget amendment, that one's been trying to get to 34 for over 30 years now, and they've been stagnant right around 27, 28 for quite a few years. So there's no momentum in that one. Anyway, so as far as a time frame, this is not a quick fix by any means. It's not something that would likely happen in most people's lifetimes. On the other hand, constitutional enforcement can happen right now, and it often does. It's happened many times throughout our nation's history. So let's get to the big one now.
Okay.
Let's get into the big topic.
States controlling, is that what you mean?
What's that?
Who can be in control of the convention?
Yeah, who controls the convention historically? And with that, we really only have one major precedent we can look to for a national amending convention. A convention for amending the national constitution has only happened once. That's when we transitioned from the Articles of Confederation to our new current constitution. 1787 was when the constitution itself was written. And some of the historical facts behind that was, number one, the convention delegates were sent with delegate commissions from their states. That's the document I have here in my hand. This is a compilation of 12 states' delegate commissions, because Rhode Island didn't even attend. So only 12 of the 13 states attended. They gave their delegates specific instructions on what they expected them to do, to not do, and so on. And here's where the real debate begins. Did those delegates obey their commissions, or did they step outside of them? And this is something that in the realm of political debate, I have been challenging leaders of the convention movement debate me on this topic. I challenge you. They are continually coming out with various things saying, oh, look, they had full authority. They stayed within their bounds. The 1787 convention was not a quote unquote runaway convention. Therefore, we have no historical precedent to worry about. We can expect the convention today to follow their rules as well. As I've read through the delegate commissions, that's not what I found. But most importantly, and probably the easiest way to point this out is, if the delegates in 1787 convention were really authorized to do what they did, why did not any of them know it? That's the question that I'm putting out there to the convention promoters. Why didn't any of them know it? Show me the one that stood up and said so. Because here's what happened. In the 1787 convention, if you read through Madison's meticulous notes, it's virtually every conversation that was had throughout the entire convention, he wrote down, Mr. Jerry said this, Mr. and so on, and back and forth, everyone's comments, everyone's thoughts. And what you see is several times throughout that convention, the question came up, do we actually have the authority to be talking about completely changing our form of government, creating a new constitution? People like William Patterson, Elbridge Gerry, Charles Pinckney, John Lansing, each raised that concern, and their position was, we do not have the authority. In fact, let me just read one of them to you here. William Patterson from New Jersey says, we ought to keep within our limits, or we should be charged by our constituents with usurpation. In fact, I could bring this up on the screen. That way you can read along. Just realized I have screen share. Let's try that.
Yep. Now,
go ahead.
Before you get into that, Robert, I thought I'd throw out a couple of objections that I've heard on this topic. Some people would say, well, actually, there have been, I don't know how many, X number of state, interstate conventions throughout the history of our country. And so we know exactly how this would go. Now, what might you say to that one? And then I've got another question for you guys.
Yeah, well, there have been a number of interstate conventions, including interstate stamp collectors conventions, and interstate Tupperware conventions and whatever. And those don't tend to run away from their authority because they don't have any authority in the first place. But as far as an actual national constitution amending convention, this is it. This is the only one we've ever had. Well, there have been a number of state conventions as well, where the
states getting together and saying about water rights or something like that.
Right. There have been some interstate ones, and again, they have minimal authority, minimal task, and they don't tend to usurp their authority in those situations. But when it comes to amending the Constitution, national or state, historically, the delegates always push their limits. And there are many, I'll share that in a moment as well. There are many examples of states where the conventions were sent with limits to their authority in the states for modifying their state constitution, and they overstepped them. I'll show you some of that in a moment. Here's in the far left column, have Patrick Henry and Robert Whitehill, William Patterson. This is the one I was just reading. We have to keep within its limits, or we should be charged by our constituents with usurpation. Let's return to our states and obtain larger powers, not assume them of ourselves. This was the position quite a few of the delegates took, was we don't have the authority, we should not proceed unless we first go back to the states and get further authorization. The response to that was not, we have the authority. That's what convention promoters today would have you believe, was, oh, they had full authority. Well, that's not what James Madison said. That's not what George Mason said. That's not what James Wilson said. That's not what Edmund Randolph said here as well. In fact, this is one of my favorite quotes from Edmund Randolph right here. There are great seasons when persons with limited powers are justified in exceeding them. That was his argument before the convention. There are times when we need to realize we need to exceed our authority. We were given limited powers, we need to exceed them. Alexander Hamilton, he wasn't concerned about that. To rely on and propose any plan not adequate to our urgent needs, exigencies, merely because it was not clearly within our powers, would be to sacrifice the means to the end. We need to do what we need to do, whether or not we were given the authority to do it. Anyway, bunch of different statements on that topic. Here's my favorite though, James Wilson at the bottom here, right in the center now. Now, keep in mind the context of this one. This one's in the state ratification debates after the Constitution was written. As the states were debating whether or not to adopt the new Constitution, it came up in the state conventions as well. The convention that wrote this Constitution weren't given the authority to do this. Here's how he answered that. He's actually defending them. He's defending their actions with this statement. The Federal Convention did not act at all upon the powers given to them by the states, but they proceeded upon original principles, and having framed a constitution which they thought would promote the happiness of their country, they've submitted it to their consideration, to the people, who may either adopt or reject it as they please. What did he just say there? They didn't act at all upon the authority they were given from their states. Now, how does that compare to what our state legislators are being promised today? They're being promised that you as a state legislator, as you create this application for convention for a balanced budget amendment and nothing else, they can't talk about anything but a balanced budget amendment. If today the delegates do not act at all upon the powers they're given to talk about a balanced budget amendment only, that would be following the precedent set by 1787, wouldn't it? Absolutely. And here's the challenge that I put out. Where's the delegate who said they had the authority? As you see at the top of the right-hand column here, we've never found a single delegate who said so. We've never found a single delegate who made the claim, yes, we do have the authority. Let's move forward with these proposals. We can change the Constitution as we need to. In fact, one other man here, Judge Caleb Wallace, supporter of the new Constitution, and for the sole reason that it was setting a dangerous precedent because it was a runaway convention. He says here, I think the calling of another continental convention should not be delayed for the single reason, if no other, it was done by men who exceeded their commission. We need to do a complete do-over just because they established it by usurping authority. And we need to disclaim this dangerous precedent. Interesting.
The only thing I've heard against this, I've seen this a number of times. Someone pointed out the end of Federalist number 40, where it seems like Madison says, hey, they didn't exceed their authority. Maybe you want to touch on that?
When someone uses that, it tells me they have been told Federalist 40 says that, but they've never read all of Federalist 40. Because if you were to look at
Federalist 40 say, maybe we need more details on that.
And that's what Federalist 40 is devoted to. Federalist 40 would have been about one paragraph long if what they're claiming is true. If they actually had the authority, all Madison would have had to have done was, here's the authority in their delegate commissions. It's right here in black and white. I'll put it into Federalist 40 so everyone can see it. We have the authority, end of story. Federalist 40 would have been the shortest of all the Federalist papers if that were true. Instead, the arguments he makes in Federalist 40 are not ones that you would see convention promoters using today, because it would undermine their argument. For example, Madison addresses the question, did we have the authority to completely rewrite and write a completely new document? He says, well, did we even really do that? Can it be said that we've replaced the document if any part of the old one remains? Where do you draw the line? Yeah, you see the rationale.
That sounds like a lawyer, right?
It's a great argument. But he also says, and this is actually part of this document I'm showing you here. This also comes from Federalist 40, where Madison also says a rigid adherence in such cases to the former, meaning to their delegate commissions. I'll just move this over here a little bit, would render nominal and nugatory the transcendent and precious right of the people to abolish or alter their governments. What he's saying is, yeah, we have the authority because the people have the natural right to abolish or alter their governments as they see fit. Is that the argument? Is that the argument that convention promoters want to use today? That, sure, let's call for a convention and they will have the right of the people to abolish or alter their governments. That's the Federalist 40 argument.
Yeah.
So when someone on the other side says, oh, they didn't exceed their authority, look at Federalist 40. This is what Federalist 40 says. That's not an argument that supports their position at all.
Well, it seems like most legislators aren't wanting to open up the whole Constitution.
Right. And that's the thing. If the Article 5 convention movement were accurate with their history, presenting this as, yeah, you might call the convention for one thing, but everything's on the table. This is an opportunity to completely reset the Constitution. We wouldn't have most state legislatures signing on to it. The vast majority would be opposed to this. It'd be very unlikely you'd see any of them being passed today. With that as eyes wide open, here's the reality of history. And so they can't sell it that way. And so they'll never admit the history that's clearly before your eyes here. I've got over a dozen of the founding fathers here declaring that the 1787 convention did overstep their power. Here's my favorite one, though. Again, this comes from the convention. This is their conclusion. How did they bring the two sides together and move forward? Madison stepped up and said, the people were in fact the fountain of all power. And by resorting to them, all difficulties were got over. They could alter constitutions as they pleased. Which means clearly, until that discovery, until that realization, they couldn't alter constitutions as they please. They recognize that. They recognize we are bound by our delegate commissions and we can't do what we feel like we need to do until we resorted to the power of the people. This one I mentioned earlier, the right of the people to abolish or alter. And the way they did that, and this brings us to what really should be the third most compelling argument in favor, is, well, whatever comes out of the convention still has to be ratified by the states, and that's a great safety net because 3/4 of the states is a high bar. Well, do you know what the high bar was in 1787? It was any changes being made to the existing constitution had to be approved by Congress and then afterward approved by all 13 state legislatures. Every state had to agree to it. So they had an even higher bar for ratification then than they do now. And it was constitutionally required, just like it is today. And 9 of the states in their delegate commissions made reference to that requirement. Whatever you come up with will then need to follow the due process of ratification as defined by Article 13 in the Articles of Confederation. And this, what Madison's talking about here, by resorting to the power of the people, what they did was they retroactively changed the ratification process. They threw out the constitutionally defined one and created a new one. Look at Article 7 of the new Constitution. The ratification of the conventions of 9 states shall be sufficient for the establishment of this Constitution. That's what they came up with, and they put it right into the Constitution. So it had its own ratification procedure built into it. Could that happen again today? If the Convention of 1787, number 1, did not act at all upon their state delegate commissions, as we mentioned earlier, and instead appeal to the power of the people, throw out the ratification process required by the Constitution today and lower the bar, that's the precedent we have from 1787. The convention represented the people, not the states. That's what Madison said here. And that is not what's being sold to our state legislators. This brings me to the other document here, which is the legal precedent. Based on the precedent from 1787, that the Convention of 1787, they went to the convention representing their state legislatures. They left saying, no, no, we represent the people, the sovereign right of the people themselves to alter or abolish their governments. Based upon that historical precedent, state conventions ever since, the courts have consistently upheld this concept. Corpus juris secundum is, as it says here, a legal summary of state Supreme Court decisions from all around the country. The states have consistently found the same direction over and over again, that the members of a constitutional convention are the direct representatives of the people, not the state legislature. And hence their power may not in any respect be limited or restrained by the legislature. And then down below here, we have a number of various state conventions where that very concept was challenged and upheld over and over and over again. This precedent set by 1787 has consistently been upheld in the states ever since. Conventions represent the people, and as such, as it says here, it's a legislative body of the highest order. It's the highest authority in the land as far as any legislative body, and the state legislatures have no authority to restrain them. That's the honest historical and legal precedent we're going into a convention with. And that is not what's being told to our legislators. That's why this is entitled, What Are They Not Telling You? Historical and legal precedent is exactly the opposite of what they're being told. Now, oftentimes, for example, a few weeks ago, about a month ago, I was in a convention hearing and Mark Meckler, founder of Convention of States, said, oh, the 1787 convention was not a runaway convention. I have this document written by Michael Ferris. I have it in my hand, actually. This Harvard Law Review that clearly debunks the 1787 convention, runaway convention thing. 36 pages. First question, how many state legislators on the committee are going to go look this up in the Harvard Law Review and read 36 pages of documentation there? I do. I always read those kinds of things. When they reference a court decision, I'm going to go read that whole court decision. That's what I do. And what I find in here is he didn't answer my question. You remember my challenges to them? Show me the delegate. He goes through all kinds of ways of getting around the topic without ever actually addressing the fact that none of the delegates agreed with what this document concludes. Not a single delegate can be found that agrees with this thing. Who knew better? The delegates that attended the convention, or a legal scholar from 200 years later?
Okay, now I just like to remind our those that are on live, if you have a question, put it in the chat. We do have a couple, I think, that are on via telephone. I'll give out my cell phone number. Don't be calling me in the middle of the night, please. But you can text me 605-999-1319. Okay, I'll give that to you again if you're on the phone. 605-999-1319. The rest of you, if you got a burning question, put it in the chat. I'd be happy to read it, and we can give Robert some questions. So sorry for that interruption, Robert, but
not a problem.
I'd like to have some questions for you. Make sure everybody goes home, with hopefully something answered that they really wanted to get answered, right?
Yeah, exactly. I'm going to stop the screen share now.
Okay.
But also, if anyone wants a copy of the documents I just went through, I think I've sent a copy of those to you, haven't I, Eldon?
I think so. Wouldn't be bad.
Not, I'll send it again. But yeah, I'd be happy to share that out as well if anyone wants to contact Eldon for that. Because the most important thing on that document is the footnotes at the bottom where it says where each of those quotes came from. Because when someone takes a quote out of context, they don't want you to go look it up and see what the context is. I want you to. I want you to go into there and see what Madison's notes said surrounding that quotation, or wherever the other sources are. So you can see the total context, that every one of those quotes is accurately representing the position of that founding father. And I challenge anyone to come up with that delegate that contradicted those statements. Because the closest they can come is Federalist 40, where Madison says, oh no, they have the authority to do it, but the reasons he gives aren't what they're making it out to be.
Well, sometimes we have people that say, well, look at me, I have all these letters behind my name, and trust me, I'm a lawyer, or whatever, right?
That's lately been Mark Meckler's main counter to what I'm saying is, well, Robert Brown's not even a lawyer. Trust me, I'm a lawyer. If you were to go into a court of law, into court hearing, and his argument was, trust me, I'm a lawyer, he'd get laughed out of court. That's not an argument. That's not evidence. That's absurd. And on the other hand, that's also a condescending statement to say, well, if you're not a lawyer, as a member of the state legislative committee hearing this, you're not qualified to even make a decision on this topic. You just have to trust the lawyers.
Yeah.
Well, that's absurd. This is like the emperor has no clothes. It's so plainly obvious to anyone who will look at the references, look at the citations, look at the evidence. And I challenge them to provide counter evidence, and they won't. I challenge them to publicly debate me, and they won't, because they don't have the evidence to back what they're saying.
So what you're saying is not to simply trust you because, people say, hey, Robert Brown knows what he's talking about, but actually look in and say, gee,
yeah.
I'm skeptical, but let me take a look and see if Robert knows what he's talking about.
Yeah, absolutely. So? And that's always the best policy. Don't just take my word for it. Like Reagan said, trust but verify. The more that people actually do that, the more credibility I have for my argument, frankly, because they'll see for themselves that what I'm sharing with them is well documented and verifiable. On the other hand, I love picking apart articles that the various convention promoters put out there, because they're very heavy on a lot of claims and very light on evidence. Even Robert Nadelson, he's kind of the scholar behind the whole movement on the conservative side. And he frequently will make references to a court case or some other source without actually citing it, without actually quoting it. And so then I go look up that court case, and guess what? It doesn't say what he said. It usually says the opposite. I could give a few examples of that, but in the interest of time, it just really emphasizes the trust but verify position. as I verify their arguments, it's not backed by the evidence. And for that reason, I continue to put out the challenge. Let's debate. Let's do a public debate. Let's actually put evidence against evidence. Unfortunately, a legislative hearing is not the best place to have a real debate. One side presents their argument, the other side presents theirs, and it's over. There's no, well, they were wrong with what they presented. There's no back and forth to show a true debate format that way. And yet that's really all we have presently is legislative hearings for that kind of debate, or public meetings like this.
I've got one of the legislators on has asked for documents. Maybe you can send those so I can forward on to him.
Yeah.
Or I could just send you his email address, whichever. And Frank is it Hester? I've got a little dot on my screen. Hester, okay. From Wheatland. I don't know if that's a question or just also wants the documentation. Maybe you want to put in the chat there. I certainly send that out.
Yeah, I'll send that over to you right now.
Okay, yeah, that'd be great.
Here.
And
that way you can forward it to anyone you have email addresses for and go from there.
Yeah, we've got some folks from Montana, Wyoming, Utah. Let's see. It says also would like documents. Yeah, okay, so Frank Hester would also like documents. So let's see. Just make sure I get, see, once I close this, I lose the chat. So I may make sure I got to write it down.
Yeah, exactly.
Okay. Okay, good deal. Yeah, it's good to have documents to be able to look yourself and share. So.
Yeah, there's more than 20 different citations to the various bits of evidence that I present there. So it's very rich in hard, fast evidence that can be verified. And I think that's vitally important. We actually know what we're talking about as we're pushing back against this. In fact, I just sent a copy of these into JBS headquarters to ask them to put together, see if we can make this into like a trifold brochure type format or something like that. So it's something simple that can be passed along to others.
Oh, that'd be nice. Yeah. Share it in that format, print it up.
Yeah. I just send it to you. You should see that coming into your inbox.
Okay. So that'd be handy. Well, I thought there'd be a bunch of people just typing questions right and left, but it's kind of
So either what has happened is I've done such a good job, I've just answered everyone's questions, or I've done such a poor job, I put everyone to sleep. Either one.
Well, I don't see a bunch of people, logging off or something, but so, one of the things that I guess I look at, you mentioned the 38 states. I hear that often. This is kind of an interesting aha moment for me, at least, was I was reading the anti-federalist papers. Now, just because they were against the ratification of the Constitution doesn't mean they didn't make sometimes good points. So Patrick Henry, he pointed out that only a quarter of the states would be necessary to stop not only a bad amendment, but a good amendment.
Mm-hmm.
So, to me, it's like, well, if you're leaving it up to the 13 worst states to, undermine this great amendment or set of amendments that are going to restore our country, I don't know, wouldn't you be looking for another option? It seems like it's so easily undermined. But
right.
That's just my, but that's basically what Patrick Henry said, and more eloquently, of course, as Patrick Henry would.
Yeah, absolutely. It really is one of those solutions, as they put out there, that just has such a remote chance of ever coming up with something good. Again, from a constitutional scholar standpoint, as I look at the various amendments that are being proposed with this in mind, that we want these types of amendments proposed at a convention, so often they're being drafted in ignorance, where it's obvious that those who drafted the Constitution, these constitutional amendments, don't have a clear understanding of what the Constitution already says and means, and are somewhat oblivious to what harm such an amendment would do. It's like inviting a love poet to do heart surgery. So if you don't truly understand the inner workings of the heart, cutting into the heart to try to do heart surgery, you're likely to kill the patient. In the same way, if you're not thoroughly intimately familiar with the inner workings of the Constitution, how various clauses work together, as you cut into one part, you end up damaging another, and so on. And I see that again and again. the types of amendments that are being proposed. One, for example, one of my favorite examples, in 2016, the Convention of States organization held a mock convention, a convention simulation with state legislators from all 50 states. And they came up with 6 amendment proposals. Most of them were pretty bad, actually. They looked good on the surface, but as you get into the details of how they would actually work and what they would change, one of them, for example, gives the states power to overturn federal law. Okay, that sounds interesting. But then they define federal law as any federal law passed by Congress, the president, or the administrative agencies. And when you constitutionally refer to the president having power to create federal law, you just granted it. And Article 1, Section 1, Clause 1 of the Constitution says only Congress has the power to do that. So you just overturned Article 1, Section 1, Clause 1 with that amendment, if it were passed. By mentioning the president or administrative agencies having power to create law, you're granting them the power. That's one of those examples of good intentions, but they didn't know what they're cutting into, and they're doing damage to the Constitution.
So if we were to stick to, say, the 3/4 states requirement for ratifying, what would it take to actually get something like that passed? I guess in my kind of thought experiment, I would imagine, let's say it's the balanced budget amendment. And certain people said, well, I don't want this or that cut. Would there be some horse trading going on if you'd actually try to get an actual balanced budget amendment, whether or not it'd be useful or not, as you pointed out?
Right.
Something to
there are really 2 things there. Number one, how many states are in the position right now to give up all federal funding in order to have a balanced budget? I don't think any state would willingly surrender their federal funding for that. But the bigger issue here is, as you're mentioning, the horse trading. What normally happens in any legislative body, state or national, when a certain bill is going through, they always have to cram it full of horse trading. I could refer to it as something else, but anyway, that in order to get the balanced budget amendment, which probably won't even balance the budget based on what I've seen so far,
Sure.
What are we willing to concede to the other side of the aisle? Are we willing to give up the Electoral College, for example? Are we willing to modify the Second Amendment? Are we willing to go into this whole campaign finance reform amendment that they're pushing for, which will be devastating as well? Are we willing to concede things to the other side? Because the way I view this, the only way you're ever going to hope to get this passed through 3/4 of the states, assuming that ratification process is left untouched, is with horse trading. It'll have to be a conglomerate, like the 14th Amendment. The 14th Amendment touches on a number of different issues all in one package deal. And that's the only way I could see any of these kinds of amendments ever passing, is a package deal type amendment.
And then how would that be sold to the public to say, we have to ratify this or we don't get anything?
Right, exactly.
That's interesting.
That's the way legislation happens today. That's why we get
true.
so much legislation that's 2,000 pages long, when it could be written on a single piece of paper if it was really for the purpose that it's stated.
Well, I do have a question here popped up. What makes the legislators think a new constitution would be followed when they are not following the one we have now? From Ken and Carolyn.
Excellent point. And that's really what Madison touches on in Federalist 48. Constitutions can't enforce themselves. And so creating more rules that can't enforce themselves doesn't solve anything. We need to get to rule enforcement, not changing them. Here's a comment from Ed Hill. Can you please recommend information from JBS to purchase and hand out to defend and not open the Constitution up to a COS? Eldon, do you want to speak to that first?
Can you please
JBS material that would be useful for handing out. One of the challenges we face.
I'm sorry, I didn't quite catch it.
Yeah. One of the challenges we face is attention span for who you're giving it to. Not you, Eldon. It wasn't a jab. But honestly, if I'm going to a state legislator who's in the middle of session and they've got to go through hundreds of bills before the session ends, and I give them an hour-long DVD that I want them to watch, they're probably not going to get to it anytime soon. On the other hand, if they're not in session during the off season, there's more likelihood that they'll watch something a little longer, a little more in depth. There are a number of videos on this topic from JBS, produced by someone that looks a lot like me, that honestly are quite good. One of them is by the same title, the Article 5 Convention, What Are They Not Telling You? Another one's called Change It or Obey It. Another one is Rein in Big Government with Article 6, not 5. All of those are really good videos for going through a lot of the documentation. There's so many angles, so many arguments that can be made. We've produced 3 full videos on the topic. There's also a number of different articles and handouts and things. Do you want to go into some of that?
Well, yeah, and those videos that you mentioned are maybe more deep than at the introductory level. So
Yep.
I always recommend there's a real good, well, a couple good videos. They're pretty short and they're cartoonish, so they're very non-threatening to a person that says, I don't know anything about this subject. I've never heard of it before. What is this? So there's one called, I think it's like 3 or 4 minutes, the Crash Course on a Constitutional Convention. Very brief, very non-imposing or anything. And then there's also the Constitutional Convention. Is that right? The Constitutional Convention versus Nullification. I'll have to, what exactly?
Something like that. Yeah, the title's similar to that.
Nullification versus Constitutional Convention. That's also very brief, 3-4 minutes or something like that, cartoonish. There's also what we call a Slim Jim, which is some call it a palm card. The one we actually have 2 Slim Jims. The one I prefer to use is called Revise or Amend. I should revise or, well, I'll have to bring it up. It's maybe I should share my screen. Can I do that and show that?
Yeah.
Okay.
Go for that.
That'll take a little bit. You talk a little bit while I bring it up, Robert.
Another place to go is on JBS's website itself, just jbs.org. And then we have the different campaigns on there. I'm going to pull that up on my computer right now as well, because it has a lot of resources available.
Okay.
Are you going to do a screen share once you get there?
I'm almost there.
Okay.
It's a lot easier when you have a picture, right? Picture's worth 1,000 words. So here we go. This is shopjbs.org. If you go to action projects, go down to Stop a Con, it's just kind of abbreviation for Constitutional Convention. So there's actually a lot of things, reprints. There's even an action pack with a bunch of stuff. So this is the Slim Jim I was referring to. Basically, it has lots of different questions on the front and the back. How would this actually work? And, you know, a lot of people have difficulty answering those questions because we just don't know. They're not answered. But there's also, there's this video about Article 6. There's rein in big government with Article 6, not 5, which is certainly, it's about an hour long, but it answers the question, what do we do?
And just briefly,
instead?
What Article 6 is about is constitutional enforcement. Article 6 is the oath of office that state legislators all swear, as well as every other elected official. And so that Article 6 goes into their duty to enforce the Constitution, and that's helping them do so.
This is
which
pretty
is
good.
really the founder's
What
solution.
will balance the budget?
Mm-hmm.
Nice one. Let's see.
Term limits, that was a good one.
There's one on term. Oh yeah, here's the dual feature. You've got nullification versus constitutional convention. And you notice all these videos are $1. So it's not like, you know, we're making tons of money on that. But,
right.
You can hand them out to lots of people, and all these videos are on YouTube too. You can look them up. But sometimes it's nice to have the disc too.
Right.
So
excellent.
Lots of good resources. Those are the ones I recommend to kind of start with. If somebody wants to know more and they like the 3 or 6 minute video, okay, why don't watch this hour long one? Or you can ask them, are you more of a visual learner or you prefer to read? The booklet, though, there is a great booklet on this subject called What is a Constitutional Convention? For somebody that's a reader, it's only 22 pages. Maybe I missed it. Well, it's in here somewhere. Yeah, I did see it. I'm surprised. You would think it'd be in this in this set of stuff that they say. Yep. But That's a real good one. It doesn't go terribly in depth, but it gives you a real good understanding overall of the subject of a constitutional convention, or convention of states, as some call it, amended convention. So I don't want to take your time too much, Robert. They wanted to
Certainly.
go into
And
that.
being that we're at an hour now, we probably
Yeah,
should be wrapping it up
probably.
as well.
Yeah.
But Eldon's name right there on the screen shows us his email address, eastall@jbs.org.
There we go.
So you can certainly send additional questions to Eldon or questions for resources. This video that we just went through right now, the recording of tonight's discussion, I guess you'll have that available as well.
Yeah, I'm gonna record this. Well, it's recorded, but I'll upload it to YouTube, and I'll probably do the audio too on my podcast, and people want to listen to it. So kind of fun. I'm glad everybody could make it tonight, and hopefully we answered your questions. But yeah, feel free to reach out to me to my email, and maybe if I don't know the question or answer, of course, I could forward it on to Robert. He's probably fielded a lot of these questions too. But yeah, it's quite a hot topic now. It's something that's somewhat divisive, especially among the constitutional conservative, libertarian, whatever people want to call themselves. But every year it seems to come up. Quite a quite a topic for discussion. It gets people kind of digging into the the details of things sometimes. Anything you want to close out with, Robert, before we?
I think that pretty well covers it.
Okay.
I think that's a great start. Of course, like I said before, we really could go to midnight. There's so much information out there, so much documentation that could be gone into for those that want to dive deeper. But this is something that I've studied for probably almost the better part of a decade now. And there's just, at some point, maybe I need to write a book, because there's just no way to cover all the information that's out there any other format.
Yeah, it's something that you can go into quite a bit, but yeah, well, thank you so much, Robert, for being on and taking the time to go into this a little bit, and just kind of give a one-on-one for everybody to get to know this topic a little more in depth, and kind of the hustle and bustle of the talking points and everything that's sometimes more brief than doing justice to this subject itself.
Yeah. I want to just make one concluding remark, and that is that honestly, my biggest regret over this whole topic is how much it divides those who otherwise should be on the same side of the battle. That many people who are strong advocates of liberty and constitutionalism find themselves on either side of this issue fighting each other. And sometimes it gets to the point where we end up burning bridges even. And I feel that's terribly unfortunate, because in the end, we all have the same goal. We may have different information, different understanding of something of that nature. And I hope that we can reach across to those on the other side of this issue in a manner that doesn't burn bridges, but at least sharing of information in an open, honest discussion, that kind of thing. Because the last thing we need is those that are defending liberty fighting each other.
Yeah, I've noticed many good people on both sides of this issue, and hopefully, another time, if you're open to it, and we can go into more in detail, kind of focus on, okay, if not this, then what? We touched on that a little bit tonight, but once again, I just wanted to thank you so much for being on, and just look forward to many more adventures on this. So,
well, thank you. Thanks for having me.
You bet. Thanks, Robert.